My lord, I grew up in Nakuru. I don't have the problem of a nail and an arm. So I know it's Mlima.
Are you the only person submitting now on this?
Yes, I'm in my minutes, the 20 minutes, I want to do 15. There were 20 minutes, yes. And I said I'm doing 15. Mr. Ongoya will do 5. That's what I'm saying. He asked for 20, I'll do 15.
All right.
And Kaminwa, because of seniority, is asking for 5. No, my lord, I have to use 15. There were very many people who say those things. So I need 15 and Mr. Ongoya will need 5. Kaminwa 5. My lord, let me start at least for one point. My learned colleague, Mr. Ndegwa, whom I respect a lot, is saying that probably we start with 2 points raised by our learned colleague, Mr. Joseph Kamoto. My lord, the first thing, what is it? Okay. My lord, the first thing is that the president cannot be sued. My lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the Constitution. So to the extent that the Supreme Court, assuming it ever says such a thing, that cannot be good law in the face of the Constitution saying everybody is under the law. Second point, my lord, what is the nature of the proceedings? These are not civil proceedings. These are constitutional proceedings. If Article 149 of the Constitution says the president shall do this, there is nothing in Article 156 that would entitle the Attorney General to be sued on behalf of the president, because the Constitution itself says the president shall do this. My lord, also, if this is Bill of Rights enforcement, if the petitioners are saying the violator of the law is the president of Kenya, then the mandate of this court is to ensure the president does not violate the Bill of Rights. Nobody else can be sued on his behalf. I think we have done with that preliminary issue. Oh, and there is these issues of vacancy. My lord, I was imagining that if this vacancy is troubling anybody in Kenya, 2 things. Number one, you would have seen some urgency in reconstituting IEBC. Some of the petitions that are before you, or that will find your way to your hands, are also saying the president cannot do what is so desperate to do because there is no IEBC. So that is coming. So if there is any urgency, anybody who cares about vacancy, let us start with IEBC. My lord, also, if, and I think Kenya are entitled to this information, Mr. Kamodo appears so ready that a vacancy in the office of the president may arise. Perhaps this is information the people of Kenya are entitled. Why is that so?
My lord, it's purely presidential.
Well, I'm not saying anything. I've ended there.
Unless you have some.
I don't know. I did say it. I did say it. Yes, my lord. Now coming to the main issue. My lord, this forum, somebody said we are sitting past the desk. It made me remember something. I think I saw the presiding judge was practicing at some time when I was practicing as a lawyer in the 1980s. And I remember going to court very many times with Dr. Kaminwa, Paul Muite, and Dixon Kamau Kuria. What was it all about? My lord, during that time, and when we could go to those cases, there was no distinction that was made.
Lord, with your very kind permission, I'm constrained to just want to get some clarification. Are we re-urging the application?
No, I'm
Because
responding.
the role you have in Illinois, you are supposed to be responding to issues that have arisen. I don't think what you're speaking to has arisen, and there is no latitude that extends to that direction. My Lord, we stand, we want to give some guidance.
My Lord, I believe those
Mr. Kibe, you gave
Yes.
the clarifications earlier.
Yes.
But now just stick to the reply according to that.
I'll do that. My Lord, one of the cases that during that time, because you know we can't address every true issue. I'm trying to be global. My Lord, one of the, and these are global points I'm making with regard to the issues that have been raised. My Lord, you are effectively being told the petitioner and the respondent occupy the same space from the standpoint of our constitution. My Lord, the truth is they don't. And I say that for the simple reason that these constitutions of Kenya was made explicitly to protect citizens who can suffer from harm from the executive and people who occupy power. That is what the protections are meant to do. Conservatory orders are given to ensure people whose rights are being violated and in need of protection, that protections will be accorded. So somebody to say that an application for conservatory orders stays on the same level with an application by a violator to continue or to complete the violations, my Lord, that would amount to misreading the Constitution. And this is not an idle issue. Under Article 20, it is very clear. The Constitution binds all state officers and this call. So the notion that we have a right to be heard, yes, when we shall be doing the petition, give them 10 hours and we shall not object. But let the subject matter be preserved. We've got no problem. The right to be heard under Mutunga rules is protected. But there is a distinction under our Constitution between a violator and the victim of violations. That one is very clear in our jurisprudence. My Lord, having said that, there is an oath of office. There is a question of the empanelment, whether you call it assignment, appointment. The issue is, for purposes of Article 165 of the Constitution, does the Chief Justice exercise judicial or administrative powers? I go with what Dr. Kaminwa says. These are judicial powers. And judicial powers, my Lord, takes us to the oath that is prescribed by believing the that schedule of the Constitution. When the Chief Justice says, takes an oath, it to exercise the judicial powers that includes, with regards to the High Court, the powers under Article 165(4) of the Constitution. No such oath is taken by the Deputy Chief Justice to enable her to do so. So that, my Lord, as long as, if you say it is administrative, we go to another level. The questions would be, can this be made without a formal judgment where the issue has arisen directly? Because as we were told by my learned colleague, Mr. Waduta, that matter is still yet to be decided by the Court of Appeal. My Lord, having said that, there's a question my learned Professor Muigai, whom I learned a lot from him. My Lord, Professor Muigai talks about public interest, the issue of the necessity for it, and about a vacuum arising. My Lord, the happy thing about the Constitution is that up to this time, the petitioners have done nothing that would elongate the time at least of 74 to 100 days that is envisaged under Article 149 of the Constitution for this business to be conducted. If anything, it is this kind of applications to set aside that will prevent these petitions from being heard, for example, in the next 30 days, so that there is still some other 30 days for the people of Kenya to be consulted on this issue and the regular decisions to be made by Parliament. My Lord, there is an issue that an absurdity is being created. Who is creating an absurdity? The absurdity, my Lord, that is being created is this. And strictly speaking from Article 25 of the Constitution. Article 25 of the Constitution says the right to be heard is absolute, even during an emergency. How can this right ever be and you do not call that an absurdity? We are actually here to prevent that absurdity. In fact, you can have a ranking of absurdity. The biggest absurdity, my lord, would be this, Article 125. All rights under Article 24 can be limited. Under Article 25, the right to be heard is absolute. It is binding on everybody. That's the biggest absurdity that can occur. Who supports that absurdity? The respondents. My lord, we go next to Professor Ojienda. Of course, Professor Gedhu said many things which we cannot deal with all of them. This internal memo, where is it? Oh, it's here. It's here. My lord, this internal memo, first of all, we note, when the question was asked, is it anywhere? It is not in the CTS. Start with. Number two, or portal for the cases that have actually been filed. My lord, the second issue, there is no reply affidavit for this court to be able to deal with it. But what does it actually say? It says, during my absence, I request you, your lordships, to be in charge. I will, however, be available on email or telephone for consultation. My lord, the last sentence, plain meaning of English, would mean to me that Chief Justice from Geneva or anywhere else she was cannot be able to carry out certain administrative functions. But when she says that to be consulted, this was clearly made in the knowledge that there are certain things that I must do, notify me so that I can do them. The appointment of judges could be made by the Chief Justice in accordance with the constitutions from Geneva. My lord, I could have said more, there is no much time. My lord, they say they are challenging ex parte orders. My lord, what ex parte orders is the main issue. The ex parte orders we are challenging is a conservatory order to ensure that before this court, there will be integrity and the constitutions will be upheld. And the kind of circus we had in parliament will not happen before you. My lord, my lord, for purposes of where do we want this matter to be completed? My lord, they said this is that they want the matter to be completed. We are more desperate for this matter to be completed. And that is why in the expectation of the petitioners, we expected that the first business of this court, like it happens every time I sit on benches, and I've sat on very many, they say, this matter is very urgent, we cannot hear preliminary matters, let's go straight to the petition. So we are very desperate to have this matter heard. My lord, there is my learned colleague, Mr. Nyamori, whom again is a good friend of mine I respect. CJI occupies 3 constitutional offices, I agree. But the only issue of distinction is, under Article 165(4) of the Constitution, she cannot be able to perform that function any more than we could say she could transfer judges. Transfer of judges is actually more or less administrative, but she doesn't do it because it is an important office that goes with the office of the Chief Justice. But if this is judicial, she cannot be able to do it. My lord, the issue of Conchela, again, the issue is contextual. The Chief Justice was a party, and therefore in Conchela, as far as I am concerned, the matter, the Deputy Chief Justice did so as an acting Chief Justice. Even Gachagua or anybody else who gets into that position, when they are acting as acting president, there are certain decisions that they can make, but they must wear that position. In this letter, there is nothing that suggests that the Deputy Chief Justice was turned into an acting Chief Justice by the CJ. Equally importantly, there is no express delegation that my powers under Article 165(4) would now be performed by the Deputy Chief Justice. My lord, the issue of Gumbo came with some funny issue on concealment of material facts. I do not know, I struggled to listen that we have concealed anything. Now, as anything, we actually even did an affidavit. they had a right to do an affidavit. It is not indicated that this document, which was in our possession, as I understand the law of disclosure, we failed to disclose it. All the other issues they are raising are points that are in contention. That does not amount to concealment, as I understand it within the law. My Lord, there was the question that no basis for Getonga Murugaros. Getonga Murugaros, I'm trying to rush. Murugara. Oh, that's very sorry. Oh, that's okay, my friend. My Lord, he says, and I agree with him, that this matter is very important for the 50 million Kenyans. I could not agree more. A matter that is so important to 50 million Kenyans, the least that could be expected is that proceedings are going to be conducted in open, without suspicions, without undue hurry and pressure. But my Lord, if the petitioners, and already they are feeling, I'm feeling pressure that I started to do, if the petitioners feel that they are under pressure in a certain matter, that is not an expressed emergency under the constitutions of Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the constitution say you should do it within around 80 to 100 days into 4 hours, there's a big problem, and that must be addressed. I'm about to finish. My Lord, so that for purposes of those issues, I agree with him. It just points out to the care that must be taken that these proceedings are not misunderstood. This court in particular must not be understood that it was under undue influence, that we must wear somebody Wednesday, Thursday, or something like that. This must be done within the 4 corners of the Constitution. If that one is not done, my Lord, there would be a huge problem, not just of perception, but the huge problem that in Githunguri versus Republic, they were talking about. The world, Africa, and everybody else is watching. And what are they watching? How are we going to consider to reduce time, for example, that is expressly set out the Constitution into hours? And to do what? To prevent a victim of constitutional violations from urging petitions that are before the court. That should worry the court more. 2 points that are remaining. Mr. Wanyama, I have to choose between Wanyama. Oh, Wanyama is the last one. The issue of Wanyama is national stability. We made several points. That is probably the only one I will address myself. In some way I can do the rest. This issue of national stability is actually very important. I agree with him. The issue of the impeachment of the deputy president raises the issue of national stability. For the simple reason, and this is why we must hear the petition, the deputy president, my lords, and as we understand elections in this country and the Political Parties Act, was not just a holder, the way you can appoint KIBE MUNGAI to be a legal officer somewhere. He was not just a holder of the office of deputy president. There was a political process in order to be able to get power under the constitution in the 2022 election. That's why the national issue of national stability arises. His supporters and also the president, they came together to form a party. So that, my lord, over and above, and there is a case which I was privileged to do in 2013, one of the lawyers in that case, this one of conflict management, when Ruto and Uhuru were being prevented from running for presidency in 2013. That case, my lord, and we did it before 5 judges. It was civilized, it was decent, there was no hurry. But more importantly, what was the issue there? Part of the issues that I was present in that case to argue is that President Uhuru and the now President Ruto are not seeking this case by themselves. because Article 38 of the Constitution says they are doing this. The peoples in exercise, their supporters, in exercise of their right, political rights, and Article 38, prefer these people to be their candidates. So what's my point? My point is this: look beyond Rigathi Gachagua. Look also to the people who feel we've not been given a square deal and we are being disenfranchised, we are being emasculated from the political scene. We shall urge that more during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring so that we can meet sometime next week and deal with the issue. My learned colleague, Mr. Ongoya, can take it from here.
You are arguing it now.
No, my lord, I have finished. My learned colleague, Mr. Ongoya, to say something.
My lords, my lady, I just have a few points to highlight. There's a question by Dr. Kamoto on